we're just waiting for a few more people to jump on. I think Connie pointed out to me that I didn't do a very good job in publicizing this session, so we may not have a gigantic crowd, but that's okay.
Okay.
We are recording this and we are translating it into Spanish.
Yeah.
And so that whatever you say will be there for people later. Angie, you'll get a kick out of this. We're using a translator. This is the internet at work, right? We're using someone who is translating for us from, is it Ecuador, David?
Ecuador, yeah, Quito, Ecuador.
Oh, wow.
We've had him doing a number of translations for 3 or 4 different projects. He's brilliant. And he's not live right now, but what we're going to do is send him the recording, and then he's going to create an additional audio feed, which is his real-time translation.
Wow.
He's a wonderful
Amazing.
man. Yeah.
A lot easier than what we sometimes have to go through with
Yeah.
translators and stuff, and a lot
But-
cheaper too.
Yeah. By the way, we have we should have closed captioning on. John, if you turn me into a host or a co-host,
Okay,
I'll see if I can turn on closed captioning.
where do I do that?
Okay, go to participants, that little 2 people icon down at the bottom.
Yep.
And my name is should be visible close to the top. And then you click on more, M-O-R-E, next to my name.
All right, hold on. So I click it twice, I'm guessing.
Just once, click on the little blue thing saying more, M-O-R-E.
Oh, I see the arrows there.
Yeah.
Invite. Oh, that's all I see is invite.
Well, I'm already here.
Yeah. Is there some way that I can just do it myself?
Yeah, look down at the bottom. Hang on for a second.
Yep.
Okay. We should set this up so that I'm automatically a co-host.
Yeah, I thought we had done that. I'm surprised
Yeah.
that it didn't.
Okay.
Oh, I see a more at the extreme right end.
Of my
Right.
name. Right.
Uh,
So if you just tap on that more.
So I just tapped more and it says live transcript. Is that what I want to hit?
Yeah, you can do that. Sure. Live transcript, and then enable live transcript.
Enable auto transcription.
That's
Yep.
it. That's it. Click on that.
Okay.
Now it's on.
All right.
And so anybody who sees the CC button, the closed caption button, can click on live transcript, and you can show the subtitles.
Yep. Yeah, I see that. That's great.
Okay. Yeah.
Okay. Well, there may be a few more other people joining us, but it's a little bit after 6, so let's get started. Thank you, everyone, for coming. Tonight, we've got 2 guest presenters, and they are from the Rhode Island Commission for Human Rights. I've known these particular people a very long time. I won't tell you how long, but it's been a long time, and I really appreciate their hard work that they do. They're particularly engaged in fair housing and housing, dealing with housing discrimination. And so I asked them to tonight speak about housing discrimination, kind of give people a general idea of what individuals with disabilities and other groups of people rights are as it relates to accessing housing opportunities. We might even talk, I'm not sure we ever see much of this anymore, but even access to credit, sometimes I think it would be an issue for somebody who has a disability or who comes from kind of a historically underserved and underprivileged group of people. So Angie is the Director of Fair Housing. Is that the official title that you have?
Well, it's a Fair Housing Project Director.
Fair Housing Project Director. And Jason is one of our senior investigators and works with her in dealing with housing and other issues. And I never did ask you guys, do you have anything that you want to share on the screen, or are you just going to talk?
We're just going
I'm
to
gonna-
talk.
Okay. All right.
I do have a couple handouts to give, which I think I can send through the chat to everybody.
Yep.
Okay.
But we just no PowerPoint for this.
Okay. Yep. All right.
Kind of going for a streamlined presentation today.
Yep. Good. Yeah. So we're going to end absolutely no later than 7:15 or 7:30 because Jay is a local celebrity in Newport.
I wouldn't go that far, but I appreciate
It's that
it.
far. It's that far.
It is far away. It is far away. So Jay has for many years been running a trivia Zoom kind of thing in the Newport area where he happens to live. And without him, it can't happen. And I think there would be kind of a revolution in Newport if it didn't happen tonight.
A
Well,
lot of fun. A lot of fun.
it was originally in a bar until the pandemic hit, but yeah.
Oh.
Then
All
we adapted, with everything else that we've had to adapt with.
Okay, so Angie, why don't you take
Actually,
Okay.
Jay's gonna take the lead. He's gonna.
Jay?
Yep.
Okay.
Good evening, everybody. I'm Jason, Commission for Human Rights, Senior Compliance Officer. How many here are actually familiar with the Commission for Human Rights? Like, raise your hands. Yeah, that's not great. That's why we're here.
That's right.
So we are the state agency that enforces state and federal anti-discrimination law. And we cover employment, we cover housing, we cover credit and lending, we cover what's called public accommodations like restaurants or bars, theaters, anything that's open to the public. And then we also have something called delivery of services, which is like RIPTA or doctor's office, something to that effect. And we are a neutral investigating agency. So we're not an advocacy group. We don't provide attorneys and we don't give legal advice. What we do is we take in charges of discrimination, making allegations that I was discriminated against because of my race or my color or sex or religion or disability, or family status and housing, which is having minor children, military status, your status as a victim of domestic violence. We have a whole group of these protected categories that we investigate allegations of discrimination based on that. Also sexual orientation and gender identity expression, age, housing status at some points, marital status. There's a lot. So trying to get them all off the top of the head can sometimes be a challenge. There's like 13 or 14 that we do on housing. And so you file a notarized charge with us and we investigate it to see whether or not discrimination took place. The role of the investigators is we gather the evidence and we analyze the evidence and we make a recommendation on whether or not it should go forward with a hearing. We feel that it's suspicious enough that there is what's called probable cause. So then it goes to a hearing, at which point commissioners will hear testimony. It's like a court trial, except without a jury. Commissioners hear testimony, there's rules of evidence, all that good stuff. And then if there is discrimination, then the commission, if it rules in your favor, can award things like damages or other remedies. So we have full statutory authority under the state of Rhode Island laws to enforce that. And in housing and also employment, our biggest category that we see is disability. And it's just gone up over the years and it just keeps going more and more. In housing, we deal with two different types of, well, for the most part, two different types of disability discrimination. The first is reasonable accommodations, which is the housing law makes a distinction between a modification and an accommodation, whereas in employment we kind of lump them all together. But in housing, your accommodations are like your policy changes or a parking spot or something that doesn't require physical change to the property. Um, Something like a live-in aid is also a reasonable accommodation, or a service animal or an assistive animal. Those are all reasonable accommodations, which we're going to talk about a little bit later on with some examples. Modifications have to do with any physical changes to the property. So think of something like a ramp, or Dr. Souza was talking about the smart technology, grab bars, or um, if you're in a wheelchair and the cabinets are too high and you need to take them down, that's also a reasonable modification. And the rules are a little bit different for both. So with a reasonable modification, the landlord, in some cases, especially private landlord, can say no to paying for it if it's going to cause what's called an undue burden, which means it's too expensive for them to do. However, if you agree to pay for it, they actually cannot deny you the right to modify the apartment to accommodate your disability. The catch to that is, though, if and when you move out of that apartment, you're responsible for restoring it back to the condition it was in before you modified it. So if you had to lower the cabinets, if you move out, you have to pay again to restore the cabinets.
But there are some exemptions now. Recently, HUD has talked about some exemptions that allow for the property to stay as is, but
Oh, good.
it's very tricky to go through it. It would be complicated. So there are some little exemptions to that rule, right? But in essence, you're right, Jay. Jay is right. In general, the rule of
And
thumb is bring it
one
all
thing,
back to normal, to where it was.
yeah, and Angie's right. If I mean, I could spend 3 hours going over exemptions with this law because of how twisty and crazy it is. But yeah, for the most part, there are some
Right.
exemptions. With subsidized housing, they don't have that much leeway because they're federally funded. It may be like such a massive thing, like having to install an elevator that for 2 floor. It might be too expensive, but again, I mean, not really going to be able to pay for an elevator if you're in subsidized housing, but they have a lot less leeway on what they deny or what they don't let you do. Um, in both reasonable accommodation and reasonable modification, there's this thing called the interactive process. So landlords or housing providers cannot flat out say no, and that's it. That there has to be more to it. So if they say no, then they have an obligation to um, work with you to find if there's an alternative accommodation that will do the same thing as what you're seeking. But it's also a two-way street. So you have to be willing to compromise a little bit on that. You might not get exactly what it is you're asking for, but if what that you are able to work with your landlord or your housing provider, and if what they work with you and come up with will satisfy your needs, then at that point they've done their obligation under the law. But they cannot give you a flat out denial. Um, Accommodations can also be something like a transfer to another apartment within a building complex. That's actually a pretty common one that we see if there's like ventilation issues or mold issues or things like that. Um, when it comes to the live-in aid thing, um, when you're asking for a reasonable accommodation, unless it's obvious on site that you need this accommodation, like say a seeing eye dog would be, yes, we can see that you have a disability and we see that you need this, so we don't have to ask really for anything. But most housing providers have a process where you have to fill out some paperwork and provide some medical documentation. You do have to establish the need for an accommodation for your disability. It's not simply enough to say, I need this disability. If they ask for a doctor's note asking to confirm that, then you really do need to submit that. However, they cannot ask you for your diagnosis, and they cannot contact your doctor. So if they ask for your doctor's phone number or email or something like that and ask to talk to them, that's a no. They are not allowed to go any further than just the note stating that you have a disability and that the accommodations that you're seeking will alleviate the symptoms of your disability or will help you enjoy your unit. Now, when it comes to the interactive process, I had a pretty interesting case. So this was a while ago, but it was probably I hate to use the word favorite, but I use favorite because the outcome was it was really, I don't know what the word to use, satisfying, I guess would be the word. You'll understand, I hope, when I say it. So I had this individual who had severe mental disabilities, and anytime he was off his medication, he had some psychotic episodes. He would drive erratically in the parking lot of the housing complex. He would rip pages out of a Bible and start burning them and throwing them into a tree that was right against one of the buildings. He attacked security guards with water bottles, did some pretty extreme stuff. But anytime he was medicated, he was one of the nicest people you've ever met. You would never be able to tell that he had these symptoms of a disability. And so what happened was the owner of the property moved to evict him, but they didn't move to evict his wife and kids. So they're only removing him from the apartment and separating the family. And this was happening a little bit before Thanksgiving, like right before the holidays were happening. And what happened was, um, his wife went up to the landlord and spoke to the landlord. It's a big housing provider, and said, "Well, if I can guarantee that he's on his medications, can he stay on the property?" Um, Basically offering an accommodation, and they flat out said no. That's not going to happen, not going to work. He's a danger, what we call a direct threat, which means there's a significant risk of harm to you or somebody else. Um, and so what happened was they kicked him out, and he was separated from his family. During my investigation, I noticed that they didn't work with his wife. They just flat out said no. They denied her and him the interactive process, and that denial of the interactive process led to him being kicked out of his unit, his apartment. Um, and it's a very unique case because it was one of the, I don't know if we've ever done this before, but we made it went probable cause, which means I felt that there was enough there to have a hearing. So it went through the process. One of the commissioners reviewed it and agreed, which they have to get to that point. And then our attorney at the time and I worked together to come up with a settlement agreement. And we actually pulled in a mental health agency in the state, a privately owned one that does a lot of work with the community. And we were able to work a deal where if he would go every week to get his medications from them, they would notify the housing provider that this happened. And as long as that was happening, he was allowed to stay in his unit. So we were able to, and that's one of the things that we also do is we try to negotiate settlements throughout the investigative process. Even after the investigation is done, the commission's always trying to find a way to resolve the case without having to go through that whole process, because it can be a little bit arduous. It's hard on everybody. You don't want to go through an investigation or be a victim of discrimination or what have you. So we do try to do that as well. And we were successful in that. And to this day, he's still living with his family, hasn't had any issues that we know about. He's even seen our attorney Frank on the street and said hi and wrote me a little note and saying that he's doing well. And that's what we do is they, in that case, they definitely, we never found that they violated the law, but it was clear that they violated the law. And we were there to make sure that his rights were protected, and we were able to reunite him with his family before Christmas, which is why I think it's such a great case, because it's that kind of outcome is what we look for when there's a violation. A lot of times there aren't, and you're going to hear a couple examples of that. But I know I mentioned animals before, and so there's a distinction when it comes to assistive animals. There's really two categories. You have your service animals, which are like your seeing eye dogs and animals of that nature. I think it's like seeing eye dog, and there's one other that really falls under that. where they are trained to perform a specific task for a specific disability. If you have a service animal, there's only 2 questions they can ask you, and they can't ask you for medical documentation. This is in the ADA. It's been quite the bone of contention in some circles, but they can ask you, is this a service animal for a disability? And what specific tasks does it perform? So you have to be able to answer that second question in order to have it qualify as a service animal. Um, on the other side, there's also the emotional support animal, which is a much broader uh, has a much broader spectrum of what's allowed. It can be cats, it can be dogs. Um, we did have one guy try to say that his python was an emotional support animal, but I don't think we were buying that much. Uh, birds can be an emotional support animal. And so if you're seeking to have an emotional support animal, it goes back to that reasonable accommodation process I was talking about. And if they ask for medical documentation, and if you get a doctor's note that clearly makes the connection between the animal and alleviation of your symptoms, then it must be allowed. And one thing that you see, there's a couple things that you see a lot out there that prevent people from getting emotional support animals, which are illegal. And one big one is a breed restriction. Breed restrictions are a no-no. You are not allowed to restrict someone's breed for an emotional support animal, because the law is very clear. They are not pets, and they're not subjected to most pet rules. They are a medical need. They're not there just for companionship. They actually perform some kind of therapeutic task. So they cannot say, well, only dogs who are 40 pounds or lower, or no pit bulls. I know that we actually, I can't say which one of the municipalities somewhere in the state of Rhode Island had that in their law. And we had a case brought against them, and we were able to convince them to change their statute that they were not
Right.
allowed to have pit bulls within the city
Yeah.
limits.
It was an ordinance. You're right. And I wrote it down, Jay. I was going to bring it up. Yeah, perfect.
I'm sorry. I'm
No,
sorry.
no, I wrote it as you were saying it, right before you said it. So I'm glad you brought it up.
So I mean, that's you can kind of see what the scope of what we can do is when we can get a whole city to change their ordinance because it violates the law. But one case that I had with emotional support animal, and it makes me laugh because I got to choose my words carefully. Some of the most dramatic people I've ever dealt with, the respondents, not the people who filed the charge, but the ones that it was filed against. Uh, so, this woman suffered from anxiety, and it was pretty well documented, and her doctor's note was one of the best ones I've seen. It was very clear. It was more detailed than it probably had to be. And so in writing, she was brilliant. She wrote into her landlord stating that she's suffering from these disabilities and she needs an emotional support animal. And here's the doctor's note that states that exactly. The landlord shoots back and says, well, first of all, the lease says no pets or no dogs, and therefore you can't have it. And then they also said, well, because we're privately owned, private owners, we're exempt from the federal law, which you can just imagine the kind of chuckle I got when I read that email. And they put it in an email. And the couple, it was an elderly couple, and they very aggressive. I would call them up, and I was trying to work a settlement with them because it was already in writing. Just from that email, it was enough because they failed to engage in that interactive process. They just said no. And so I talked to them, and the talks consisted of me talking to them and taking turns screaming at me. They would pass the phone back and forth and just scream at me, which was fine. I'm used to it. At one point, the male, the husband, threatened to shoot the dog if he saw it on the property, which was just a wild thing to say. Eventually, it went probable cause, and it was a shame because their denial, she had a dog already lined up with a shelter that she was going to adopt. She found a dog that she really liked and wanted to bring it home, and she lost that ability. She lost that right to that dog because of the egregious behavior of the landlords. Um, Egregious to the point that one of their attorneys told us that they're the devil incarnate. Like it got to that point during the settlement talks that their own attorney talked to our attorney and said, my client is the devil incarnate. So we do deal with some very interesting people sometimes. And you have to have the patience of a saint. But in that case, I think they finally settled because she moved out, because she couldn't have her dog and it was really affecting her disability. So she moved out and there was, I believe, a monetary settlement. But it was, I don't know how Frank settled it. I think their other attorney kind of let them know the reality of the situation, that when you put in writing the denial of accommodation and there's no basis for it. Yeah, they switched their excuse. The other things, they kept switching their excuses. First it was no dogs on the lease. They also told her they thought her disability was made up, which was just beautiful. They also said that he's allergic to dogs, even though they don't live on the property, which didn't understand that. And then the final one was that because they're Holocaust survivors, she's scared of dogs. So every time I would counter what their excuse was and why it wasn't valid, they would come up with a new one, which obviously was not legitimate. But in that case, she had all the paperwork that she needed. She had a good doctor's note, and it was the denial of the interactive process and the just outright denial of the dog, citing a pet policy, by the way, in their lease, which again, emotional support animals and service animals are exempt from most pet policies. You still have to clean up after them. You still have to make sure they don't attack people. You have to make sure they're not aggressive, but the breed restriction, the weight restriction, those are exempt from those. And so I'm going to turn it over to Angie right now to give you some examples of other reasonable accommodation and modification cases that she's gone through and what the resolutions of those were. So Angie, take it away.
So as an example of, he brought up aggressive animals. I have two cases that were interesting cases that give you an idea about aggressive animal. One of them, I call it the, HUD has this, I don't know, it's in somewhere in the statutory language about this, I call it the one bite rule. So I had a case in which an animal, and it was a pit bull. So the individual suffers from severe anxiety and requires the aid of an emotional support animal. The individual submitted the medical documentation and everything, and ultimately the landlords wanted, she had already moved in, but she provided that information after the fact. And that will happen. We've seen many cases like that, where they don't tell the landlords up front about their emotional support animal until after the fact. And that is, of course, that's something, but that doesn't make it a no cause case because they told them after the fact. If the individual is able to establish that they require the aid, that they're disabled and require an emotional support animal or a service animal, then that is what matters. That trumps not telling them in advance. In this particular case, this animal, the young lady was walking outside with the animal, and it's a pit bull. The animal was off the leash. Long story short, the animal bit the next door neighbor. Not anyone in the building, but the next door, one of the neighbors. And it's a small block. And so a bunch of people in the neighborhood got together and went to the landlord and and demanded that he evict that woman, and that something happened, that dog needs to be euthanized. Well, the woman, so what happened was the way the animal the animal bit this neighbor was, she walked over to the dog. She's a dog lover. She went over to the dog to pet the dog. Now it's a hot day. There was a child playing on something, some kind of banging on some drums. So the dog, from what I gathered, was dog got aggravated between the heat, the noise. It was a busy day and a lot of people out. And then the woman was coming over to pet him in the midst of him and he was in an excitable state. And so he jumped up and kind of like nipped her on the leg. So yes, but she didn't want to pursue anything. She didn't file any, she didn't call the police. She didn't want to try to sue the young woman. She did get stitches, the tenant, and she actually wasn't one of the people that wanted the woman evicted, because she felt partly responsible for the action. So the landlords failed. So the charging party, she filed a complaint. We investigated it. And what we concluded was that it's the same thing that Jay spoke about earlier. The landlord was working vigorously to try to evict the young woman because of that incident. But there's a rule, as I said, there's this whole one bite rule. So yes, the dog bit someone, but the landlords had a duty to have an interactive discussion with the charging party to make sure that that kind of situation doesn't happen again. So after much discussion, much debate, even having to have a meeting with all the tenants because they wanted to be part of this dialogue. So I went out to the property, one of the community rooms, and everyone got to complain and tell me why they wanted this dog gone. And at the end of the day, it's up to the landlord and the charging party to work something out. I wanted them to give them the opportunity to hear them out, explain the process, explain fair housing, how it works, and the need to have an interactive discussion and to allow the charging party an opportunity to remedy, do whatever necessary, whatever she can to make sure that situation never occurs again. And so at the end of the day, the matter was resolved because rules were put in place, meaning she can't be outside in the common area on the street in that neighborhood unless the dog is on a leash, of course, at all times. And she had to make sure that the dog, there's a crate in her house in the event there's any, they have to do maintenance work or anything in the house, so that, because you have people who are afraid of pit bulls. She said she's had the dog for many years. It's never bitten anyone before, and it's possible. It could have been, obviously it was an isolated situation. And so she had to have a crate. There were certain conditions that were put in place, but allowed the charging party to continue to live in the property. But there was also something that helped to protect the landlord in that if she didn't comply with these conditions and they're able to prove it, then they can move to immediately evict her for not complying with the terms of that agreement and placing people at risk of being harmed by this animal again. So that was, there's a situation where, and pit bulls are a big deal in a lot of the cases that come before us. That's what Jay was talking about as well. And many people have pit bulls, many, and not all pit bulls are bad. They got a bad rap. There was another situation where there's
Angie?
Oh, yes.
Before you move on, Camille has a question.
Oh, yes.
Camille, can you unmute yourself, please? Camille, there's a microphone symbol in the lower left. If you click on that, Angie and Jason will be able to hear you. Can somebody else unmute Camille?
Oh, maybe Dr. Souza can.
I don't know how to do it, but
Yeah, we can't unmute somebody from the host side because it's a privacy
Oh.
consideration.
Maybe Camille, can she type it in the chat?
Yep.
While Camille is typing,
Okay.
I don't want to get too far ahead, but one of the things that I'm aware of the commission doing sometimes, and maybe this is already in your outline and just address it where it is in your
Sure.
outline if I'm jumping too far ahead. But sometimes someone with a disability will go to rent an apartment and the landlord will say, oh, gee, I'm so sorry, we just rented it. And the commission sometimes has a process to kind of check that story.
That is correct. So yeah, what we do is we can ask for documentation. We can ask to see the copy of the application. If there is a physical rental application, if there's a lease, we can ask to see the lease. We can look and kind of compare the lease or the application to see if something is, something funny went on. And Oftentimes we go out to the property and interview people in person. So to get more information, because it's not all it can't be done, housing investigations, everything can't be done on paper. Everything can't be done over the phone. Lots of times in these kind of situations, you actually have to go out to the properties and talk to witnesses.
Super.
So have we heard from Camille?
Still working on it?
Have not heard from. I think what she was asking about is actually testing, where sometimes we send people to the properties to see if they're being treated differently. So we'd send one person who's disabled and one who's not, with like same set of qualifications, and to see whether or not the treatment between the two are different. A lot of times that's if we get a complaint from somebody that doesn't want to file a charge, but it may be an ongoing problem, or if it's like a systemic issue with a big housing provider. But we do that at some points. Yes, we have run what we call testing in some cases as well.
Yeah. And we've also, in those kind of situations, we've been very successful at the very early stages of the investigation, being able to resolve it. If the landlord has still has an available unit, even if it's at another location, and then it's up to the charging party to accept or reject. But we've been able to remedy the situation that way, where the charging party accepts another apartment in the same building or elsewhere.
Thank you very much.
Yep.
I don't see a note that Camille has typed.
Oh, well, maybe she can jump in whenever she needs to.
Yeah.
Okay.
Sorry for the interruption.
Oh, no, anytime anyone has a question, feel free to interrupt. I'd rather answer your question while you're still, brainstorming.
And I also have the chat open, so I'm watching it in real time just in case something comes up.
Can I just ask how difficult it is, or how often you actually find that landlords are discriminating against a person with a disability? Is it very hard to do, or do you see it happen to actually prove it?
And in general, percentage-wise, it's a case by case. That's there's no straight answer, blanket answer for that question, because and percentage-wise, I can't tell you how many cases we've had probable cause for disability. I can only tell you the majority. A lot of cases we find there's insufficient evidence to find to determine whether a discrimination occurred, which is why settling is such a big deal. That even when the case is looking like it's going poorly for the charging party, that doesn't stop the investigators from continuing to try to work something out so that everyone can walk away satisfied to some degree. But even in those cases where it's unsubstantiated, though, it doesn't mean that I tell people who walk away unhappy that when they don't prove their case. But I think there might have been something there, but this wasn't enough evidence. I just remind them, don't think of it as a loss. Look at it as an education to the landlord. This may not happen to another person. I just look at it as a win because you brought it to light.
Yep.
Yeah, and the other part of that is like it really does depend on the evidence you get in the case. Like my dog case I talked about was super easy because they put it in writing. But then there are cases that are going to be a lot of he said, she said, no witnesses, no real documentation, and those can be difficult. So it really depends on what you're getting in a case, and nothing is standard. Trust me, nothing is standard.
So I did want to talk. Oh, go ahead.
Before you guys go on, maybe this is a good place to interject here. So can you talk a little bit about our role in providing a public prosecutor in terms of housing cases, which is different from some of our other areas of jurisdiction?
Well, it's because with our HUD contract, in dual file cases, it's mandated that when we file, because all cases are dual file, well, not all cases that have federal and state statute, we dual file with HUD. And so in our HUD contract mandates that if the matter goes to a hearing, or even if a right to sue, or if it goes, the respondents or the charging party opt to take it to a state court, our civil prosecutor has to follow that case. So we basically have to defend the probable cause finding. not necessarily the charging party, but in essence it is. We kind of do, because we're following and we're following that probable cause finding. So we are still defending. Even if the charging party in that case already has an attorney, we still have to, our civil prosecutor still has to be in part of that process. It's mandated.
Yeah, at that point, it becomes the state of Rhode Island versus rather than the complainant versus. Although a lot of times it'll be the state of Rhode Island and the charging party versus.
Yeah, I think this is important for people to understand that even when you're in a situation where you don't have an attorney or you don't feel like you can afford one, if we find probable cause and we start moving down that process, we can provide legal support in that case.
Only if it's dual filed though, if it's state
Right.
only. Yeah, if it's a
right.
state only case, meaning there's only, less than 4 units, landlord lives in the property.
Yeah.
Then no, we would not be able to, and the charging party would have to try to obtain an attorney.
But
Yeah,
a
and
a large percentage of our cases are dual filed, so
But the majority are dual filed, yeah.
you shouldn't, I guess my point to people is don't be afraid if you don't have an attorney. We'll decide whether we can provide some support, and if we can, we will.
Right. And we have
But-
mediators throughout the entire process. We make sure that we allow both sides to know that if you, not only are the investigators make every effort to try to resolve, to help the parties come together with some kind of resolution, we also have trained mediators. So the investigation can stop, you can schedule a mediation, and the investigation, the investigator knows nothing about what takes place during that whole mediation process. If it fails, the case comes back to the investigator and the investigation resumes forward, just so you know that. And the mediation's free, just like our service. So there's no charge for that. And at any time, the charging party or the respondent can ask to schedule a mediation during and even after a probable cause finding, can ask for a mediation then too.
Yep, all of our services are free, so there's no fee to
Yep.
file a charge. There's no fee to have an investigation. None of that.
And I don't think that Jay explained, I'm going to step back a little bit. It's important that you also know that the filing a charge of discrimination with the commission, especially with housing, specifically with housing, we do it, we can do interviews over the phone with the charging party and draft a charge from the telephone interview. You can send us an email, you can fax us information and we can draft a charge that way. It doesn't have to take weeks and months for a charge to be drafted. Oftentimes prior to COVID, we had people that walked in, we interviewed them, and then we drafted the charge right on the spot.
We're also working on, and I'm one of the people doing this, on being able to electronically notarize your charge too. Because you can't come into the office, but we do provide notary services for our charges.
Right.
And again, that's free charge as well. So we're actually at the process where we would meet on Zoom if you filed a charge, and we would be able to notarize your charge. So there would be no delay in actually getting that filed with us.
And also, because of COVID, we've come up with some better mechanisms to allow parties to, now we can interview via Zoom. We can have our fact findings via Zoom. One of them is a predetermination conference where it allows for a commissioner to be part of that fact finding process. So we have all the parties present and we can go through the process of interviewing, asking questions so that each side gets to hear the answers and give a rebuttal. So it's a great opportunity to hear everything all at once. And it helps move that process along much quicker. I tend to use it quite a bit. I find that it's a very useful tool, especially in sexual harassment cases, because then in sexual harassment cases, it's a he said, she said. So in order to determine credibility, you want to see the parties. You want to be able to visually see them and hear them and let them tell their stories again and see if they left anything out, which oftentimes happens because now you have everybody right in front of you. So that's another tool in our arsenal that we use. So Zoom, I mean, this COVID thing, it's a horrible thing, but it's brought to light some tools that we hadn't thought of that it's more accommodating for a lot of different reasons.
It also, this is just me being cheeky a little bit, also takes away the excuse as well. We don't want our people to fly in for a day. Well, now you don't have to.
Right.
Yeah.
Correct.
Yep.
So I just want to give you a couple more examples of accommodations that cases. One of them, recently I had a case where an elderly woman needed rugs removed from her unit. She lives in subsidized housing. She has respiratory problems. And I actually visited her home. You can eat off her floor. I mean, it was immaculate. She was 89 years old, immaculate in her house. But the rugs, even though they look brand new, they were causing her a lot of breathing problems. So she asked to have them removed because she had been living in the unit for about 20 something years. And the rugs are the same rugs. So the landlords fought against it. And it's subsidized housing. They fought against it. They said it was too expensive. And that was another case in which after much back and forth, a lot of investigation, a lot of on-site visits and discussions with the landlords and with the property managers, they finally came around and realized that this was going to go cause. This was going to be a probable cause slam dunk. There was no reason to say, I mean, it's federal property. It wasn't going to be that expensive to put a hard floor. She wasn't asking for any specific type of expensive floor, just a removal. So vinyl, anything could have been put in place. And so ultimately that is what they wound up doing. But you would be surprised what a hard time they gave this woman and me, and going back and forth and talking about this very simple accommodation. So that's a rug one. Then, we were talking earlier before everyone came on about live-in aids. Dr. Susan brought up a couple of questions. So I just wanted for those, because there seems to be a lot of folks here that are not familiar with the commission. And I think it's important that you understand that when it comes to a live-in aid, and it goes back to, for the purpose of this discussion, I'll start with, for subsidized housing, we all know that they calculate a person's rent in assessing what their rent will be. I mean, assess their income to determine what their rent will be. When an individual requires a live-in aid and they've shown that they qualify for the live-in aid, they need someone to live in their unit with them to assist them. That live-in aid, their income is not assessed. They get to live in the unit and that income is not calculated as part of the rent. Now, if anything happens to that tenant and that tenant stops living in the unit, then of course that live-in aid has to leave immediately. They can even put a lock on the door. They don't have to go through the whole, I mean, I've seen it where they've had to go through eviction process because the individual wouldn't leave. But the live-in aid is required to leave because they're not technically a tenant. They're only there to assist that tenant.
Angie, expand a little bit more on this. How about a family member functioning as a live-in aid? For example, a 25-year-old man has his mother living with him. If
it's subsidized housing, the rule is the same. I mean, they still have to, unless they become a tenant, they can become an occupant if they qualify. They can, but then their income gets calculated.
Okay.
So if they want to be added to the lease, then certainly then their income will be calculated, and that's different. Then they get to, if it's disabled elderly housing and they're not disabled or elderly, then of course they would have to leave. But
so if it's not an elderly parent, but a brother or a sister, a sibling, same rules apply, whether they're related or not.
That's right. And anyone, when it comes to subsidized housing, and you want to be, and the individual selects a live-in aid, that individual, that live-in aid has to go through the same application process. They have to qualify to live in subsidized housing. So you can't have a criminal record, whatever it is, the application process is, that live-in aid has to technically go through the same background checks and all the same application process. And the only difference is their income won't be calculated if they are approved to live with that tenant.
Yep. Okay.
Now in private housing, that's a different situation. I have seen where landlords will increase the rent because there's an additional occupant in the property. So then that would have to be investigated to assess, to determine what was the nature of the income, why and how they came up with that number. And so, lots of times, in most cases, even in private housing, increasing increasing the rent because somebody suddenly needs a live-in aid, oftentimes does not work out well for the landlord, even in private housing,
Mhm.
unless they're able to establish something that that has been considered.
Great. So I got one more question, then I'm going to stop. But I see that Bob Marshall has joined or has been on for a while. So talk a little bit about housing discrimination as it relates to source of income or source of benefits like Section 8 vouchers.
Yeah.
And
Well, we're still, that's, source of income is not a protected category in the state of Rhode Island yet. But there's been a lot of many years working. I've testified before the Senate myself, a House and Senate, and many of us over, and some people at Rhode Island Housing and a lot of housing providers have been involved in trying to impress upon the legislators to include source of income as a protected category. And crossing my fingers, I hope I'm not jinxing it, but it looks like it may happen this year. So we have our fingers crossed, and if that happens, because there are other states that do have it. So that would mean people who are being denied housing because they have a Section 8 voucher, which I can't tell you how many calls I get like that, where they simply, no application process. They don't even get an opportunity to even to look at the unit half the time. As soon as they hear the word Section 8, landlords don't want to talk anymore. They hang up. So source of income gets passed in the state of Rhode Island, that would be phenomenal. So even people who are receiving, who are on disability, people get turned away because they are on SSI. So that would all qualify under source of income discrimination, those types of things. So it's all about being able to give someone an opportunity, the same opportunity you give anybody else, the same application process, the same consideration, not asking for special favors, just give them the same opportunity to be considered. So that's what source of income protection hopefully will bring about.
great.
Right,
Thank
and
you.
it's funny that she says that, because a lot of the misconception is that a reasonable accommodation is special treatment, when it's not. It's giving equal treatment and letting them, whoever has the disability, have equal enjoyment. There's nothing special about it. It's not like they have an exemption to the rules. It's, well, in some ways they have an exemption to the rule, but it's, so there's no barriers to them. It's breaking down barriers. It's not giving special treatment.
Good point.
Jason and Andy, this is Dave. Can you, is there any way that this group or people affiliated with this group can lend their voices to that source of income conversation and to the presentation of that material? That's a big deal.
Oh, that's a good point. Brenda's on here. Brenda Clement. I think Brenda Clement was part of the source of income fight. Brenda, do you have any information? I know I can certainly talk to Amy Ramon over at Rhode Island Housing. She seems to be one of the people heading this thing off, and see if that would be beneficial. Brenda, do you have any information you can share?
Yeah, I apologize. I'm double booked, so I'm back and forth between meetings
okay.
as well too. But so Homes RI has been working with Rhode Island Housing on the source of income legislation. It's actually scheduled for a vote in the House committee coming up this next week, so we're hopeful that it will move quickly through the House this time, and the Senate has passed it several times before, although have to repass it again this year. But the House has been where it's been stalled before, so we're optimistic. But if you go to homesri.org website, you can get some up-to-date information about it, and I'm happy to share it with the group later on when I'm back at my computer.
So, hey, Bob, could you just jump in? Bob Marshall has been very active in all that stuff too.
I'm sorry,
I was just checking because I've been tied up in hearings all afternoon, and I just checked, and it is scheduled tomorrow for a vote.
Tomorrow, sorry, I'm losing my weeks. Yeah.
No, that's okay.
Oh, that's right, it's tomorrow.
What I was worried about, and I was waiting for it to pass, and it has now passed, was whether or not there was going to be a sub A that we got it. Because I was surprised that it went to consideration so fast after being blocked so long in the House.
Yeah,
But,
no, we expect it to be moved.
Sub A was, no sub A was filed today, so it's not going to be amended. It's going to pass as introduced.
That's
and
our plan.
usually- Yep, usually if something gets scheduled for consideration and gets voted out, they've already counted the votes on the floor. They tend not to send things to the floor that aren't gonna pass. So, it's looking good.
Yeah, and
Um,
it is good news, and the Speaker of the House is doing a press event sometime on Monday afternoon, talking about kind of housing initiatives and priorities that he would like to move through his chamber this session. And so he is talking about source of income at that, or where at least hopeful that he will. And so I think it's likely that if it passes committee tomorrow, that it will be posted for pretty close to immediate consideration on the floor, which will be great news.
That would be great. It's been a
Yeah,
long
that's
time.
likely. If it does pass tomorrow, I'll let John know, and I would suggest that every one of you call your rep.
Yeah, I've already,
You know,
you've all gotten emails from me asking you to do that, so keep doing it.
Yeah.
Keep-
Yeah.
I wait for it to pass tomorrow, and then get on your rep, get him on the phone and tell him he has to pass it. And tell anybody you know that lives in a different district, have them call too. So.
Yeah, so we got our fingers crossed. It's been many years, long battle.
Yes,
Just in
it has
time,
been going on
I'm
for way
retiring.
too long.
I'm retiring in April. I wanted to see it pass before I retire.
Oh,
Well, you should call Takashi and tell him that. He's the type that would do it just for that.
yeah, and Representative Camille Vella Wilkinson is somebody that is very friendly to us in that respect. She actually was a former member of the commission. She's been a big ally. So if you live in Warwick, give her a call, and I know she's going to vote for it. But
Yeah, absolutely.
Yeah, especially the Providence people who have mainly been the people that killed it in the past. So anybody in Providence, call your rep.
Actually, that's not quite true. It's actually been Cranston and the speaker, previous speaker, Providence City
previous speaker
Council
had a big
actually
role
just
in it.
Providence City Council just actually passed a source of income
Yeah.
legislation in the city as well too, as applies to the
Yeah.
city. So so it really was stuck before in the previous speaker who was not in favor of the bill. But things have changed, as we know.
good. Okay. So
I
anybody
raised
else?
my hand old school because I'm old school. Jason and Angie, can you address the issue of when an adult with a disability is not able to advocate for him or herself? How about, do you have experience with parents filing on behalf of their son or daughter?
Jason, I'll let you answer that one. How about you answer that one?
I mean, it's such a legal question. I think if they have power of attorney, I'm pretty sure they can
Right.
do that.
Or legal
may be-
guardian, they can.
Yeah,
They
it
absolutely
may be
can.
also be if there's a medical need, we make a reasonable accommodation to our policy. That it has to be whoever is filing a charge be the one that does it. One thing that I want to point out, which I didn't say before, is you don't have to use like the magic words reasonable accommodation. That's a myth. It could just be casually say it, I need this. You don't have to use those words specifically in order to actually request one, which a lot of people think you do, but you don't. You can just say, I really need, I might need the carpets ripped up. Please, can you please do that? You're not going, I need a reasonable accommodation to have my. So there's a lot of misconceptions about that, but it's not as formal as it appears. They may have a formal process with their paperwork, but you don't have to use those words. I don't really have any experience myself with that scenario that you came up with.
I have. I've seen one. I've had case or two like that. And as long as the individual had, they had legal guardianship over the person, so they can file on behalf of.
So just to put a fine point on this reasonableness and the meaningful dialogue. So tell me what you think about this particular scenario. Somebody calls and says, I would like to do something, and the secretary at the office says, no, that's against our policy. And thank you very much. That's obviously, that's not a meaningful dialogue. How about if they say, send us a letter asking for this, and you send the letter and then you get a letter back says no? Is that sufficient, reasonable, meaningful dialogue, in your
No.
opinion?
I would say no. If they simply say no, then they did not engage in the interactive process. They have an obligation that if they have an obligation to do more than just say no, they have to present alternative accommodations, or at least work with the person requesting them. A flat denial is just not allowable under the law.
Yeah.
I think Ms. Sappert had a question.
I did. Two questions now, actually. When you say you need a power of attorney to file a claim for someone else, doesn't
Attorney
the
or
rehabilitation
legal guardianship.
Or legal
Something
guardian.
saying that
or
you're
legal guardianship, right? But doesn't ADA and the Rehabilitation Act to file for someone else? I thought, because, can you hear me okay? I have a new computer.
I'm trying to hear the question.
Okay. I thought the ADA and the Rehabilitation Act provided for that you could file on behalf of someone with a disability.
Private organizations can. We do have private organizations which will file on behalf of individuals. But if you have like
Okay.
an individual filing on behalf of an individual, there's certain legal requirements you have to meet.
Well, if they agree to it, obviously, but
Right.
but I thought it was in the law,
It
but
actually-
I defer to you. I just always thought that was the case. But
Actually, there's a way that you can address that now that we passed a couple of years ago. We passed something called supported decision-making, and you can go into that without doing the whole guardianship process. So if you had somebody that was in this situation and they felt they couldn't handle it on their own, you could sign a supported decision-making agreement where they name someone to assist them with that process,
mhm.
and then you file
Yes.
that agreement with the housing
Yeah.
authority, and they have to honor it. It's in, we got it into Rhode Island law, it has to be honored. So anybody that's in that situation, you don't have to go out and get a guardian just so you can file one complaint. You can just do it with the supported decision-making. Where the person would get, what that does is it would say, I'm assuming you're talking about a family member, it would allow, if they appointed you, and it's up to them, they can appoint somebody other than a family member, but whoever they appointed has the power to go in and do all of the talking, gather all the information. They can't make a decision. They then bring that all back to the person, help them understand it, and then that person can make it. But they can go to the point of filling out the paperwork and doing that kind of stuff, and then just having them sign it. All of that now is legal in Rhode Island, and it holds the same sway in those situations as a guardianship was, except that person can't make the decision to file the complaint. The individual has to make that decision.
Right.
And my
And
other question,
oftentimes we ask them to sign something if they're able to give us something in writing, giving the authority to have this person advocate for them so that we can contact that person as the advocate on their behalf. Yes.
right. And my other question is, I came in late, so you may have addressed some of this at the beginning, but do you also do pattern and practice type? Like, if you have a situation and you realize that it's affecting a lot more people, do you do that kind of investigation also?
Yes, we
And
do.
we were in a situation, this is not housing, but we were in a situation where we asked for something, and we ended up having to explain it was a reasonable accommodation because it was turned into the word complaint was used. They considered it a complaint when we requested something for someone with a disability. And so there's something I'd like to do about that. And so I wondered how one contacts you also. If I missed that at the beginning, I apologize.
Well, I guess I would need to see exactly the details of that, because that's, yeah, so we can connect the dots to see how it would impact that particular individual. It still has to be, it impacts this individual, and it has an overall rule impact on people with disabilities. Yeah. So I'd have to see it all in writing to determine whether or not
this would have been an accommodation in a medical situation.
Yeah, I would have to see it in writing.
So,
yeah.
About that, we do that. This isn't, we do that, but we also have been in some instances referring cases and working with the U.S. Attorney for Rhode Island on that. So not only are we doing it, but they're also doing their own pattern and practice investigation as well on the federal side.
Yeah, that's right.
For their statutes. So we've actually referred a couple cases to them as well.
Okay, I would really like to talk to you then. So
we'll give you our email address. I think I'll give it to Jay, since he's going to be taking over after I leave, filling in anyway. So Jay should give you his contact information. There you go.
Okay.
Yep,
Thank you, Jason.
You're welcome. I know, and the reason I brought it up is I know they're specifically looking at hospitals and medical cases. That was one of their big focuses.
Yes. But this is probably because of COVID. This isn't a COVID related thing. This was even prior to COVID. I wasn't surprised at what happened with supports during COVID, but this is even beyond that. It's a much wider issue, and I have a lot of good evidence of that. So.
All right. Well, I love you.
Email that to Jay.
Start that off. Yep.
Jay, put that up again. Is it in the chat?
Yeah, it's in the chat.
Thank you. Okay. Thank you.
Okay. Anyone else have any other questions?
All right.
Wow. Okay. Yes. So thank you.
John can't see my hand. One of the things that we have found with regard to a medical need is that a letter from a physician often handles it before we even have to go to an organization or an attorney to file a complaint. And Sharon, the person who files a complaint is called the complainant, and that's not a pejorative statement. That is.
Well, no, I went to an office in this, like a patient, services office in this facility, and I asked, who do I speak to about an accommodation for a person with disability? And they didn't have one. So all they had was patient services. And so it had to go in as a complaint. And I am still asking who one speaks to if one needs an accommodation in this facility, and they have no name. They have no name, they have no procedure. We asked for a private room in a certain part of the facility, and it turns out they are mostly private rooms. They had very few rooms that weren't private rooms, but they were irritated and they said we demanded a private room. So you couldn't even ask because we couldn't even get into the proper discussion because
Yeah.
they were irritated that we even asked.
So their misclassification
So,
of reasonable
yeah,
accommodation.
and there was also an equipment issue. My son uses a wheelchair. We went to pre-admission testing and they didn't even have a wheelchair scale for him. And they asked if he could stand for a minute. And finally, they did manage to get, they said, well, you know, the day he went in for his surgery, they brought something to weigh him. So there's a lot of issues that I'd like to talk
that
to you about.
facility.
There's just a general not, and one of my hugest complaints is there's always handicap parking outside, but waiting rooms never have parking spaces for wheelchairs. It's like they don't expect anybody in a wheelchair to be in a medical facility in Rhode Island. I mean, everywhere I go, I put in at this place, I put in something about that, and I've never heard from anyone, but it's like, could you please make some spaces so you're not like people are walking around you saying, excuse me, there's no place for
No,
people,
that's a
as if
situation.
it's not welcoming, you know?
That's a situation where the Governor's Commission on Disabilities could be helpful.
Okay.
Because they have their own people that go out and look at things like that as
So,
well.
yeah, so I'm trying to make some, some change, and this also meant, it was very hard. My son ended up having to be in the hospital for an extra week and a half because they wouldn't do this. And I finally had to talk to an attorney who told them to read the ADA, and we were fine. So, but, you know, so anyway, but I'd like to make some more systemic change, and that'd be great. I'd like to talk to those other people from the feds.
Okay.
Thank
Hi,
you.
Okay.
Sharon, this is Catherine Taylor. I just wanted to say I'm a commissioner on the Governor's Commission on Disabilities. And
Hi,
the
Catherine.
staff person you would want to talk to on the commission is named Denise Wilhelm. And she will really be all over this issue.
Yes.
Okay. Yeah. Oh, I've even, by the way, my son has even gotten a letter about doing some sort of testing procedure, and they say it's written right in the letter. If you can't get up on the table, you need to bring something so that you can get up on our table. You bring the accommodation to get up there. I have an actual letter that says that.
Okay.
Yeah, they're really
the other-
specific
the
about.
The other place you might want to send this information is the Disability Law Center has also been gathering stuff on medical access.
I'm aware. I know
They are
there's,
pulling that together.
right, there was a case about signing, being able to sign to accommodate parents.
Yep.
I know it. It's somewhere. Thank you.
Well,
Thank you.
Sharon,
Yes.
Sharon, you know that there's a lot of education that needs to go on. This is just a silly little personal experience. So today, Connie and I went to get our first flu vaccine. We went to this huge facility. And when I go out in public, because I don't see very well anymore, I usually carry my white cane with me and use it. And I got to tell you, we must have run into 50 people who work in that facility who did not recognize that carrying a white cane is usually done by people who are blind. They just assumed that I could see, even though, you know, I had this thing and I was waving it and stuff. So yeah, there's a lot of education that needs to go on.
Yeah, but you wouldn't think it would need to go on in a medical facility.
You would think
So
so.
I would
In the first
really
place.
like to start there, because that one really bothers me. So,
Yeah.
I'll tell
Yeah,
you.
Understandably so.
it's
Understandably
wonderful
so.
now. They have these stickers for people to put on their masks if somebody is deaf, because they can't lip read anymore.
Yeah, right.
With all of us wearing masks.
Yeah.
So
I was gonna
you
bring
know,
that up.
I've been posting that on my
Yeah.
Facebook too, you
Yeah.
know, it's like, it's tough, yeah.
I've-
But
I've had
medical
more than-
facilities need to be more tested. And I just want to tell you one more thing. My son is an actor who uses a wheelchair, and he was with a group, and they asked at one of the, I'm not going to mention the place, at a at a training, they were training doctors to deal with people with disabilities. And they said, oh, and we've got people, and we've also got this one actor who actually uses a wheelchair. Didn't want him. They didn't want him. So, yeah.
Anyway,
So
okay.
there's a little resistance.
So let's get back. We're just about out of time, and
Sorry.
I know Jay's got to go, and I appreciate everybody who has been involved. I'm glad that I was able to get Angie and Jay here to kind of just stimulate us a little bit in thinking about these things.
If you need us to come back next month, we can come back next month if you have some questions.
I don't know. We'll see. We'll see. So let me just say, for
There was
those
one thing I want to say real quick.
Yep.
Just in the cases that I've had, the biggest misstep with doctors' offices I've seen is interpreters for deaf and hard of hearing.
Yeah.
They don't understand their responsibility,
Oh, yeah.
their obligation to actually provide them. I've had quite a few cases go probable cause on that.
Yeah.
Yeah.
Sorry.
Okay, so thank you, everybody. Let me just kind of like preview this next couple of weeks. Next week is kind of an open night, and I'm going to actually send out an email reminding everybody, and I'm going to post some questions. Basically, I'm interested in people's ideas about actions for the future. And then Michelle is here, and she has offered again to help deal with individual questions. So Michelle, do you want to just take a minute to talk about when you're going to be offering that office visit on Zoom? She probably has to.
Thanks. We had our first call last week. It's myself and Betty Murray and Anne LeClaire. And we were happy to have people participate. So we're going to do that in March, on March 10th, from 6 to 7, the same Zoom link. Moving forward for April and May, we're looking at the third Wednesday of the month, but next month it will be March 10th. And we're really here to listen to you. We've already set up meetings to get some of the questions answered that you were talking about on the call. So we're really excited about taking what we're learning on these calls and moving it forward in Rhode Island. Thanks.
Great, thank you. And then at the end of the month, we're going to have Gloria Quinn, who is the former executive director of West Bay, Rhode Island. She's got a lot of experience as a provider in both in Rhode Island and other states in terms of providing support to individuals who are living in their own places, either homes or apartments. And so we'll explore that aspect of housing alternatives. So
And that's at the end of April, huh?
end of March. End of March.
I mean, end of March.
Yep, the last Wednesday of March. So thank you all. Thank you again for everybody. Thank you, David, for all of this tutoring on Zoom. Probably by the time we're done with this, I'll probably know how to use this crazy thing. But
Jason and Andy, I want to thank you from all the way across the country. This was clear and extremely helpful. And I just wrote Jason, I said, you've just lent a whole lot of energy to this group. So terrific. Stay in touch with us, please. Okay.
Okay.
Angie, we're going to miss you.
Oh, no, you can still, I'm still going to try to do everything. I want to continue to advocate and help wherever I can. So I just said I'm retiring, but I'm still going to be around. Anybody needs me, all you got to do is call me.
That's right. I know how to get to you. Yeah. Okay, great.
Okay.
Great.
Thank you all. Have a good night, and we'll see you all next week.